Hello. Let's continue with Board of Directors, Trustees, and Officers. So first, we're going to distinguish a director from a trustee. So a director usually is what you call uh, to a stockholder who's been elected as a member of the board in a stock corporation. If that person or a member is in a non-stock corporation, you call him a trustee or board of trustees. Okay? And the board of directors shall be elected for a term of 1 year from among the holders of stocks registered in the corporation books. While for the trustee, for a term not exceeding 3 years. So director 1 year, for trustee 3 years. A director who ceases to own at least one share of stock shall cease to be such. A trustee who ceases to be a member of the corporation shall cease to be such. Meaning, what is the qualification of a director or a trustee? For one to be a director, one must hold at least one share of stock. So kahit pa isa lang yung stock na hawak mo sa isang corporation, you could be elected as a board of director, as a member of a board of director. Okay? And for on the part of the trustees, okay, as long as you are a member, okay, you can be elected as a board of trustee. Okay, yan lang yung qualifications under the revised corporation code. Yan ang qualification ng isang director at ng isang trustee. Of course, logic will tell you that that board of director or board of trustees must be of age, di ba? Must have the ability to consent, di ba? Hindi naman yung insane, yung baliw, di ba? So, yun. Each director and trustee shall hold office until the successor is elected and qualified. Now, this is very important. Sabi natin kanina, director shall hold the term for 1 year, while a trustee for not exceeding 3 years. Okay? Now, kapag wala pang magre-replace dun sa board of director or dun sa board of trustee, they can sit there until the successor is elected and qualified. Okay, so kung walang inelect, kahit pa 2 years na si board of director or 3 years na or 4 na, board of director pa rin siya. He shall sit there until another director is elected. Si trustee naman, kahit pa nag-exceed na siya ng 3 years, he can sit there as long as wala pang na-elect na bagong board of trustee. So, tatandaan nyo yun. That's very important. Okay? What does a board of director or board of trustee do? Under the revised corporation code, the board of directors exercise the corporate powers, conduct all business, and control all properties of the corporation. So, PBP. Powers, conduct all business, and properties. Control all properties unless otherwise provided in this code. Okay? So generally, the corporation acts through the board of directors or board of trustees. As we all know, it's a juridical person, it's an artificial being, therefore hindi siya tao talaga. So hindi siya makakapag-act talaga in itself. It acts through the board of directors or board of trustees and the corporate officers. When it comes to acts of management, what you need is only the board of directors or trustees. In other words, these people are the decision makers in a corporation. When we talk about acts of ownership, of course, you still have dadaan pa rin yan sa board of directors or board of trustees, but for approval of stockholders or members. Why? Because this is an act of ownership, an act of dominion. Okay, therefore, the owners should have consent. That's why after the board of directors or the board of trustees decide on this act of ownership, it must be approved by the it must be approved by the stockholders. Okay? So, wait lang. Magbayad lang ako ng Jollibee. Okay. There are 3 levels of control. So, na-determine natin pag-acts of management, the decision makers, board of directors, or board of trustees. When it comes to acts of ownership, it must still board of directors or board of trustees, but must be approved by the stockholders or the members. When it comes to other areas of concern, sabi natin kanina, board of directors, yung management, they create corporate policies and they manage the corporation. When we talk about corporate officers, they merely execute the policies laid down by board of directors or trustees. Therefore, corporate officers cannot decide. Ang decision maker, sila board of directors or board of trustees. Si officer, siya lang yung mag-execute ng directive ni board of director or board of trustees. Stockholders, they merely hold residual powers over fundamental corporate changes. Ano ito? Ito na yung with regards to what I said earlier, acts of ownership. Okay? That decision by the board of directors cannot be valid unless it is approved by the residual powers of the stockholders or the members. Okay? So, yun yung 3 levels of control. The board of directors or board of trustees decides if corporation can enter into a contract. Sabi ko kanina, di ba? Decision makers through a board resolution. A corporation acts through its board of trustees or board of directors. Okay? Can a corporate officer exercise corporate powers? Generally, the answer is no. Okay, unless that certain corporate officer, whether it be the president, secretary, treasurer, or the compliance officer, okay, has been conferred by a power by the law or by the revised corporation code, by the articles of incorporation, by the bylaws, or if that power is conferred by the resolution of the board of directors or trustees, then you can say the corporation can exercise corporate powers. Okay? Business judgment rule. So, sabi natin kanina, the board of directors or the board of trustees, they are the decision makers in a corporation. So, whatever they decide on with regards to the business, it should be followed. Yun din ang sabi ng Supreme Court, yun din ang sabi ng Korte. Contracts intra vires. When we say intra vires, contracts within the powers of the board of directors or board of trustees entered into by the BOD are binding upon the corporation. And courts will not interfere unless such contracts are so unconscionable and oppressive as to amount to wanton destruction to the rights of the minority. So, sabi ng court, you respect the decision of the board of directors as long as it is not unconscionable and oppressive. Okay? Sabi pa nila, courts won't override the business judgment of the BOD because courts are not in the business of business. The business of courts is not business. It is better for the state to leave business to businessmen. That's why the courts emphasize the respect as regards to decision making of the board of directors. You can see naman if that decision by the board of directors is unconscionable, and oppressive. Okay, but if everything is done in good faith, if everything is done intra vires, okay, then that business judgment by the board of director must be upheld. Okay, yun yung tinatawag nating business judgment rule. Hindi makikialam ang korte dyan. Kahit pa magkaso sila, sabihin lang ng korte, business judgment rule, courts are not in the business of the business. Sir, paano kung nalugi yung business? Dahil dun sa decision ng board of directors. If the decision of the board of directors is done in good faith, as long as wala silang rights na nalabag, it's business eh. There is a risk in business. You all know that. Financial management, marketing management students, you know that in terms of business, there could be risks. Okay, pwede kang malugi. So, in case na malugi ka, hindi ka sisisihin ng court. That is a business judgment. An error in business judgment is not bad faith. It's not a violation of business judgment rule. Okay? Hence, BOD or BOT should exercise corporate powers in good faith, care and diligence, and protect the interests not only of the majority but also that of the minority of the stockholders, because as we all know, guys, the board of directors or the board of trustees or the corporation itself always acts on the decision of the majority, di ba? It is always the decision of the majority of the board of directors or the majority of the stockholders, hindi yung minority. Sir, paano naman kung yung minority, paano naman sila? Okay? That's why we also have what we call derivative suit. Ito yung remedy ng minority. Why? When BOD or BOT are guilty of breach of trust or bad faith, a stockholder may institute a suit in behalf of himself and other stockholders and for the benefit of the corporation to bring about a redress of the wrong inflicted directly upon the corporation and indirectly upon the stockholders. So this is their remedy. Gaya ng sabi natin kanina sa business judgment rule, as long as it's not oppressive and unconscionable, pwede. But if it becomes oppressive and unconscionable, or there is bad faith, or the acts of the BOD or the BOT are not anymore for the best interest of the corporation, then any stockholder may sue in behalf of the corporation. Take note na, these stockholders sue in behalf of the corporation. So, ang main party dito, si corporation. Si stockholder is what we call a nominal party. Nominal party lang siya. Ibig sabihin, siya lang yung nag-file ng case on behalf of the corporation. Okay? Derivative suit. Independent director. Okay? Dun sa board of directors, meron dyan independent director. Okay? Meron dyan independent director. A person who, apart from shareholdings and fees received from the corporation, is independent of management and free from any business or other relationship which could or could reasonably be perceived to materially interfere with the exercise of independent judgment in carrying out the responsibilities as a director. From the term itself, independent of management and free from any business or other relationship which could or could reasonably be perceived to materially interfere with the exercise of independent judgment. It's important to have independent directors because there's also what we call corporate politics. Okay, that's why there's what we call the majority and the minority. Okay, that's why it's important we have independent directors to really see and identify if the acts of the board of directors are really for the benefit of the corporation. When do we need independent directors? Okay? The board of the following corporations with public interest, vested with public interest, shall have independent directors constituting at least 20% of such board. Meaning, not all corporations require independent directors. Kailan mo lang kailangan ng independent directors? When the corporation is vested with public interest. Sir, paano namin malaman kung yung corporation is vested with public interest? Ito yon. Number 1, corporation whose securities are registered with the SEC. If the stocks are registered with the SEC, they are vested with public interest. Corporations listed with an exchange, if the stocks is registered with the PSE. Okay? Or, the corporation has assets of at least 50 million pesos. So, kung yung asset ng corporation is 50 million pesos, and having 200 or more holders of shares, each holding at least 100 shares of a class of its equity shares, they are corporations vested with public interest. Okay? Registered with the SEC, yung security, listed with the PSE, assets of 50 million, and having 200 shareholders, each holding at least 100 shares. Corporation vested with public interest yan. Second, banks and quasi-banks, NSSLAs, pawn shops, corporations engaged in money service business, pre-need companies, trust and insurance companies, and other financial intermediaries. Yan, included dyan yung non-stock savings. Itong NSSLA pala, non-stock savings and loans associations, or yung mga microfinance, yan. They are vested with public interest. Okay? Third, other corporations engaged in business vested with public interest similar to the above. So kahit wala dyan, basta similar to number 1 and number 2, they are considered corporations vested with public interest. But you have to submit that to the SEC because it will still be determined by the SEC if with public interest ka yung corporation nyo. Okay? Taking into account relevant factors which are germane to the objective and purpose of requiring the election of an independent director, such as the extent of minority ownership, type of financial products or securities issued or offered to investors, public interest involved in the nature of business operations, and other analogous factors. Independent directors must be elected by the shareholders present or entitled to vote in absentia during the election of directors. Okay? Speaking of election of directors or trustees, each stockholder or member shall have the right to nominate any director or trustee who possesses all of the qualifications. Diba? Yun lang naman. If director, he must only hold at least one stock. If trustee, he must be a member with the right to vote. Okay. At all elections of directors or trustees, there must be owners of majority of the outstanding capital stock. Or if there be no capital stock, majority of the members entitled to vote. Meaning, during the election, dapat present yung majority holders of outstanding capital stock or majority of the members entitled to vote. How will they vote? Whether in person, through representative, authorized by a written proxy, okay, through remote communication or in absentia. Ito yung bago. Remote communication or in absentia. But take note that under this, dapat authorized siya in the bylaws or by a majority of the board of directors. Meaning, you can only vote through remote communication or in absentia when authorized in the bylaws or by a majority of the BOD. If this is not authorized by the BOD, if this is not authorized in the bylaws, then there is no such thing as remote communication or in absentia. Okay? Itong remote communication na to, because of the changes in time, okay, considered na rin siya for purposes of quorum. So not everyone can attend, especially now in the pandemic. Okay, anyone can engage into what we call remote communication. Regarding as to what, maybe the company can determine that for itself, how they will conduct remote communication. The election must be by ballot if requested by any voting stockholder or member. Total number of votes cast shall not exceed the number of shares owned multiplied by the whole number of directors to be elected. Okay, you do the math. No delinquent stock shall be voted. Meaning, a delinquent holder of a stock shall not be voted, and I believe it cannot also vote. Okay? Basta delinquent yung stock. Corporate officers. So tapos na tayo sa board of directors or trustees. We now move to corporate officers. Sabi natin kanina, they merely execute the policies laid down by the BOD or the BOT. They manage the corporation and perform duties as may be provided in the bylaws and as resolved by the BOD or the BOT. So kung yung BOD yung nasa taas, yung nasa baba nila is si corporate officers. If the acts of the corporate officers are within the authority laid down in the bylaws or by the board of directors, they are binding. Otherwise, not binding. Unless, of course, ratified by the BOD or the corporate officers are esto. Okay? Sino yung corporate officers na to? Number 1, president. Dapat merong president sa isang korporasyon. Okay? Itong president na to must be a director. So dun sa board of directors, board of trustees, they can either elect or appoint a president. Take note, director siya, hindi stockholder. Director dapat siya. Second one, treasurer. Required din ito. Lahat ng corporation dapat may treasurer. And the only requirement here is that one must be a resident. Take note, for one to be a treasurer, he must be a resident, meaning dapat nandito siya sa Pilipinas. Why? Because treasurer siya, babantayan niya yung funds ng corporation. Okay, and you cannot do that if you're not here. Diba? Kahit hindi siya stockholder, kahit hindi siya director. Okay? Pwede siyang maging treasurer. Kasi ang requirement lang ng law is resident. Number 3, kailangan to secretary. Secretary. Tandaan, ang secretary dapat citizen, meaning Pilipino. And resident dapat nandito siya. Okay? Other officers provided in the bylaws. If the bylaws provided for other officers, vice president, diba? Mga ganyan. General manager, mga ganyan. Pwede silang corporate officers. But if they are not provided in the bylaws, they are employees, corporate employees. Iba pa yung corporate officers sa corporate employees. Yan ang mga issues sa law school. Compliance officer, this one is new. Diba, tandaan yung sabi natin kanina, we need independent directors only when the corporations are vested with public interest. Ngayon naman, you need compliance officer when the corporation is vested with public interest. Why? Because of the regulations imposed by by the departments of these corporations. Okay, they must comply with all the rules laid down by these departments. Kaya siya corporation vested with public interest because it is being regulated by government agencies. And compliance officers will ensure that they meet or they comply with the regulations imposed by these agencies, different government agencies. Ayan ho, dapat po meron niyang mga yan sa corporation. Tandaan, hindi laging kailangan ng compliance officer. Kailangan lang siya pag incorporation is vested with public interest. Beware or caveat. No one shall act as president and at the same time secretary, president and at the same time treasurer. Pwede pa siguro, yung secretary mo is at the same time your treasurer, pwede. Pero hindi pwede yan. President and secretary and president and treasurer. Quorum at the meeting of Board of Directors or Board of Trustees. A majority of the Board of Directors or Trustees shall constitute a quorum for the transaction of corporate business. Diba sabi natin kanina, Board of Directors or Trustees are decision makers. Okay? And they will meet from time to time whenever necessary. Let's say for example, in the transaction of corporate business. Okay? And there can only be a quorum if there is majority of the Board of Directors or Trustees present. Ano yung majority? 50% plus 1. Unless articles of incorporation or bylaws provide for greater majority. Meaning, if there are 15 Board of Directors, the majority there is 8. Diba? 15 divided by 2, 7.5 plus 1, 8. Diba? So 8 is the majority. Okay? Why do we need to determine if there is a quorum, sir? If there is a quorum, any act or any decision made during that meeting, okay, shall be valid. They shall be valid corporate acts. If there is no quorum, then it is considered as there is no meeting. Kaya importante merong quorum. And why do we need to discuss quorum? Because of this one. Since nasa corporate officers tayo, sa election of corporate officers. Who will elect corporate officers? The Board of Directors. Okay, vote of majority of all the members of the board. Tandaan nyo, sabi natin kanina, in an ordinary meeting ng Board of Directors or Trustees, majority lang ng BOD ang kailangan, 50% plus 1. So dun sa 15, kahit 8 lang ang meron sa meeting, may quorum yan. Ibig sabihin, pwede silang mag-act, pwede silang mag-decide. Dito, hindi pwedeng 50%, okay, plus 1. Dapat vote of majority of all the members of the board. Why? Paano yan? Yung sabi ko na, 15 BOD, 8 yung quorum, corporate act can be validated. Ang kailangan lang na vote para maging valid yung act is 5. Majority of those present in the meeting. Kung corporate act. Pero kung election ng corporate officer, the vote required is 8. Majority of all the members of the board. Say for example, 15 BOD or BOT. 8 yung majority to constitute quorum. Okay? To elect a corporate officer, itong 8 na present, dapat unanimous ang decision, ang vote nila para ma-elect ang isang corporate officer. Otherwise, hindi ma-elect kahit pa 7 yan nagbo-vote. Why? Because ang basihan is not the members present in the quorum, but the majority of all the members of the board. So kahit yung absent, dapat bilangin. Okay? Yun yung sa election of corporate officers. Ngayon, once an election happens, you need to report that. Saan mo yan nire-report? Sa SEC. Sino magre-report? Secretary or other officer that is assigned by the corporation. Okay, ano ang nasa report ni Secretary? Ito, the names, nationalities, shareholdings, and residence address of the directors, trustees, and officers elected. Okay? Within 30 days po yan, ibibigay ni Secretary dapat sa SEC. Okay? Kaya kailangan niyang names, nationalities, shareholders, residents, para malaman din yung compliance no corporation as regards to the laws. Say, for example, the laws on the citizenship of the corporation. Kung ilan dapat ang citizens of the Philippines na member ng corporation and member ng directors. Kasi minsan merong mga requirements yan. Depending on the type of the business. What if there was supposed to be an election but they did not conduct the election? You also need to report that within 30 days after the said election sana na hindi natuloy. Okay? Within 30 days dapat i-report yan ni Secretary sa SEC. Tapos yung nasa report niya is yung date nung yung date nung bagong election date. Okay? Which shall not be later than 60 days from the scheduled date. Okay? Ano ang gustong i-imply ng bagong, this is new revised corporation code. Okay? Anong gusto niyang i-imply dito? That you need to commence your operation, di ba? Sabi natin noon, you need to commence and organize the corporation. Sabi natin noon yung with regards to 5-year non-continuous operation. When you are not able to commence and organize the corporation, within 5 years, marirevoke siya. Okay? Kaya meron itong reportorial requirement, okay, to allow the corporation to commence and organize. Okay? Kasi kapag hindi, may 5 years lang sila, marirevoke yan. Unless kapag nakapag-commence ka at makapag-organize, after 5 years, meron ka pang 2 years to start or to commence your operations. Diba? Yung delinquent corporation na sinabi natin before. Okay? Yun kapag walang nangyaring election. Diba? Nag-set ka ng bagong date. Ngayon, paano kung yung bagong date na sabi mo mag-elect kayo, hindi natuloy? Okay? Or, if dun sa report ni Secretary, wala siyang bagong date na nilagay, anong pwedeng gawin? Okay? Any stockholder or member or any director or trustee may apply directly with the SEC. Okay? With regards to election of board of directors, trustees, or the corporate officers. And the SEC may summarily order that an election be held. Anong ibig sabihin nitong summarily order? Wala nang hearing yan. The SEC, upon verification or confirmation that indeed no election was held upon the rescheduling, okay, the SEC can order immediately that an election be held. Wala nang hearing. The Commission shall also have the power to issuance of notice stating the time and place of election, as with regards to that, designated presiding officer as regards to election, and the record date or dates for the determination of stockholders or members entitled to vote. Hello? Sino pa to? Oh, nga. Hello. Oh. Oo, bilang Kaam. Dala mo dyan. Oh, mag-kuhan ka lang ng kuhan. ID. Ha? Yan kuhan. Ano na nila ko? Tsaka kuhan lang depende magkano benta mo. Maski kwan lang. Pag ganyan kasi, depende sa kwan. Sa value ng kwan, ng benta. Pero kung ganyan naman, 500 na lang yan, dalawa. Huwag mo nang isipin yung kwan. Oh. Kasi kung ibabase ko din sa porsyento, mahal. Eh, kailangan mo ng pera eh. Oh. Oh, ayan eh, kwan, kahit 500 na lang yan, dalawa. Huwag mo nang isipin yung kwan. Oh. Kailan ka punta? Bukas? Oh. Kailan ka punta? Kunin mo yung full name, address, yung civil status nung ng benta. Ay, nung bumili. Ikaw naman na may-ari, no? Ay, meron na. Sige, mas madali. Oh, mas madali yan. Sige. Sige. Kasi Gmar. Punta daw dito. Sa harap ko na yung daan mamaya. May klase ako. Okay, so next. Sorry. Should a director, trustee, or officer die, resign, or in any manner cease to hold office, the secretary or the director, trustee, or officers of the corporation shall, within 7 days from knowledge thereof, report in writing such fact to the commission. So, nang-imagine nyo, yung may nagtanong sa akin nung last meeting, what is the difference between a sole proprietorship and a one-man corporation? Siguro ito na yun. Yung sinasabi ko noon na regulation. Because every now and then, lahat ng mangyayari sa corporation, you have to report to the SEC. Unlike if you're a sole proprietorship, hindi mo naman nire-report yan sa DTI. Okay? Saka ka lang magre-report sa DTI pag foreclosure ka na. Pag lugi ka na. Okay? Yan lang. Disqualification of director, trustee, and officer. Isarado mo yung if within 5 years prior to election or appointment, tandaan nyo guys, disqualification of director, trustee, or officer. Dapat itong disqualification na to 5 years prior to election or appointment. Number 1, convicted by final judgment. Okay? Tandaan, convicted na siya, hindi pending yung case. Okay? Convicted by final judgment. There has already been a final judgment. Of an offense punishable by imprisonment for a period of 6 years or exceeding 6 years. So kung less than 6 years yan or 6 years lang yan, okay, hindi siya disqualified. Okay? Violation of this code, meaning the revised corporation code. Violation of securities regulation code. Okay? Second, if that board of director, trustee, or officer is found administratively liable for any offense involving fraudulent acts. Okay? Ano ibig sabihin niyan? Administratively liable. Hindi criminal, hindi civil, administratively liable. Sa trabaho. Ayan. Involving fraudulent acts. Why? Because you are going to be a member of a board of directors or trustees. You're going to be a corporate officer. Okay? Decision making, lahat sa inyo. So kung meron kang history of fraudulent acts, you will be liable. You will be disqualified. Okay? By a foreign court or equivalent foreign regulatory authority for acts, violations, or misconduct similar to A and B. If foreign yan. Kasi foreign court. Or kahit pa hindi foreign, kung Pilipino yan, pero merong judgment by a foreign court or foreign regulatory authority. Okay, as long as the same offenses, the same causes as A and B, disqualified ka pa rin. Hintayin nyo daw? I-check mo. I-check mo nga kasi ano. May tawag si Madel kanina. Yan, hindi lang pa. Ay, hindi na lang ba? Yung bayad ko, wala. Ay, wala pang number to. Ay, ano yung nasa number nyo? Yung naka-check?
17.
Ha?
17.
Hindi lang. 20 na ito. Ba't na yan? Marami na.
Baka inaayos niya yan. 20 book 3.
Book 3. Ba't hindi ko paras?
Hindi, lista niya siguro pa kung naka-open mo.
Book 3 na. Ano lang mga yan? So, nakapamay ito. Nakapamay ko ito. Parang na. Mag-7 to lang naman yung next. Ikaw na?
Basahin mo na.
Okay.
Isa lang na yung ID na.
Ha?
Isang xerox na.
Oo. Kano na lang ito, ma? Saan yung ID? Kano siya nagbenta? Siya ba nagbenta? Jane, ma. Ito isa. Yung ito, ha?
Wala ID na.
Okay. Removal of directors or trustees. Okay, tapos na tayo din sa disqualification. Ngayon naman, removal. Paano ma-remove ang isang director or trustee? Una, there should be notice, of course. Notice to stockholders or members for removal. Siyempre, i-gather mo lahat ang stockholders and members. You state in your notice the time and place. The place usually yan, the office or the principal address is stated in the Articles of Incorporation. Yun usually. Intention to propose removal. With that comes, dapat kasali na rin sa agenda nyo yung pag-fill ng Board of Directors. Since meron kayong tatanggalin, dapat kasali na rin sa agenda nyo is yung kung sino yung ipapalit nyo as Board of Directors or Trustees. Then, publication or written notice to the stockholders and to the concerned director. Okay? Then, how do you vote? 2/3 vote of outstanding capital stock. Take note, outstanding capital stock. Kung wala namang stock, 2/3 of the members. Okay? For non-stock. Paano? Through a regular meeting or special meeting. Okay? Kung special meeting yan, of course, specially called for that purpose. It may be called by the secretary on the order of the president or on a written demand of stockholders holding majority of the outstanding capital stock or entitled to vote. Tandaan nyo kasi, kaya nung sabi ko kanina, corporation ito, it will always be the decision of the majority. Okay? Kung ayaw ng majority na board of director na si ganito, yan, makita nyo yung letter B, written demand of stockholders holding majority of outstanding stock. So they can vote a director out of the board. So yun yung power ng majority. Okay? What if there is no secretary, sir? Or si secretary, nakalimutan niyang schedule. Okay? If there's no secretary or the secretary, despite demand, fails or refuses to call the special meeting or to give notice thereof, the stockholder or member of the corporation signing the demand may call for the meeting by directly addressing the stockholders or members. These are instances, rare instances where involved directly ang stockholders. So kung walang ginawa secretary or hindi siya nakapag-call ng special meeting, pwedeng si stockholder or member ng mag-demand for a meeting. Removal can be with or without cause. So, kung ayaw ka talaga ng majority, kahit pa ang daming magandang ginawa sa corporation, they can remove you without cause. Okay? Kahit pa for reasons of corporate politics. Okay? Provided that removal without cause may not be used to deprive minorities, stockholders, or members of the right of representation to which they may be entitled under Section 23 of this code, meaning representation via proxy. Okay, because this is, this establishes the power of the majority. So ang ibig sabihin nun, ang tatanggalin ng majority, syempre si minority yan. Okay, so it secures the right of the minority as regards to representation. The Commission or the SEC shall motu proprio or upon verified complaint and after due notice and hearing order the removal of a director or trustee elected despite the disqualification or whose disqualification arose or is discovered subsequent to an election. Ano ibig sabihin nito, guys? Okay? Sometimes, because of the decision of the majority, okay, sometimes they will elect a director or a trustee na disqualified pala. Or, may disqualification siya na nag-arose later or na-discovered later. Okay? Anong pwedeng gawin? The SEC shall either by a complaint by the minority or motu proprio, ibig sabihin po ng motu proprio, on their own. Kapag nalaman ng SEC on their own, they can, after due notice and hearing, remove a director or trustee na dapat pala in the first place disqualified. Okay? Itong removal nitong director na to shall be without prejudice to sanctions that the SEC may impose on the BODs or trustees who have knowledge of that disqualification failed to remove such director or trustee. Okay? Meron din kasi, kaya yan na-elect. Aware sila na merong disqualification, yet they still elected them. Itong mga nag-vote or itong mga aware of that disqualification but still elected that disqualified board of director, okay, can also be sanctioned. Okay, so hindi lang yung disqualified ang matatanggal, may sanctions din against dun sa bumoto or dun sa may alam, may knowledge dun sa disqualification nung disqualified board of director or trustee. Ngayon, there are instances wherein there is a vacancy in the office of director or trustee. Okay. And we know the importance of board of directors or trustee as regards to decision making in the corporation. Kung kwan, ibalik na lang dito yung ID ng isa. Kung kwan, sabihin mo muna na kwan. Para daanan niya na habang naghihintay. Okay, if the vacancy scored is because of other causes other than removal, or other than expiration of term. Paano siya ma-fill upan? By the vote of at least a majority of the remaining directors or trustees. If there are 15 board of directors, nagka-vacancy ng isa, other than by removal or by expiration of term, 14 sila, majority of 14 is 8. So 8 should vote. Okay, kung sino ang ipapalit nila. If still constituting a quorum. Paano kung because of the vacancy, wala ng quorum? Ito na. Si stockholders or members nang mag-vote. Okay? Since walang quorum, hindi maging valid yung corporate act, yung owners na mismo, yung stockholders or members na ang mag-replace or mag-fill ng vacancy. So take note, kung other than removal or expiration of term, majority vote of the remaining BOD or BOT. Kung wala ng quorum, stockholders na ang mag-vote. Paano kung vacant because of expiration of term? On the day itself, dapat ma-fill upan na yung position. Why? Because that is expiration of term. Alam nyo kung kailan mag-expire yan. Dapat prepared kayo dyan, so dapat palitan. When the vacancy arises as a result of removal. Kung may natanggal. Okay? The election may be held on the same day of the meeting. Yung mga sabi ko kanina. Okay? Kapag nagko-call kayo ng special meeting for removal of a director or trustee, mas maganda isama nyo na sa agenda ng meeting yung pag-fill up dun sa tatanggalin na board of director or trustee. Just in case, mapagbutuhan na dapat matanggal. Okay? In all other cases, the election must be held no later than 45 days. Okay? From the time the vacancy arose. A director or trustee elected to fill a vacancy shall be referred to as replacement director or trustee and shall serve only for the unexpired term of the predecessor in the office. So, sabi nga natin kanina doon sa pinakauna, a director shall only serve for 1 year and a trustee for not exceeding 3 years. Okay? So, kung si director na-replace siya 8 months pa lang natapos niya, yung mag-fill ng vacancy na yun, okay, tatapusin niya lang yung 4 months. Okay? 4 months lang kasi 1 year yun. Okay? Ganun din sa Board of Trustees. They will only serve the unexpired term. However, when the vacancy prevents the remaining directors from constituting a quorum and emergency action is required, basta walang quorum, guys. Okay? Basta walang quorum and emergency action is required. Why emergency action is required? Ito yung tinatawag ding emergency board. Why emergency action is required? Because kung hindi sila mag-elect ng bagong director or trustee, pwedeng magkaroon ng grave, substantial, and irreparable loss or damage to the corporation. Para maiwasan yan, kailangan ma-fill upan yung board of directors or trustees. Ngayon, kung i-schedule mo pa yan sa stockholders, matagal. Kaya ang ginagawa, the vacancy may be temporarily filled by the officers of the corporation by unanimous vote of the remaining directors or trustees. Ibig sabihin, yung mag-fill up dun sa board of directors or trustees is isa sa officers ng corporation, yung corporate officers. Okay, and sino mag-vote? Yung remaining directors or trustees kahit walang quorum. Kasi ang sabi natin kanina, quorum, kapag may quorum, valid ang corporate act. Pero ito kasi special instance. Why? Because there could be grave, substantial, and irreparable loss or damage. Para maiwasan yun, sige, kahit walang quorum, pwedeng mag-vote ang directors or trustees para lang maiwasan yung grave, substantial, and irreparable loss or damage to the corporation. The action by the designated director or trustee shall be limited to the emergency action necessary. So, since this is an emergency board, okay, yung action niya lang or yung powers lang ng emergency board is limited to that need only. Okay, and the term shall cease within a reasonable time from the termination of the emergency or upon election of the replacement director or trustee, whichever comes earlier. The corporation must notify the Commission or the SEC within 3 days from the creation of the emergency board, stating therein the reason for its creation. Tingnan nyo, the regulation is very strict. When you elect emergency boards, you still have to notify the Commission or the SEC. Any directorship or trusteeship to be filled. Yung kanina, vacancy. Ito naman, vacancy because of the increase in the number of directors or trustees. Wala talagang vacancy, nagka-vacancy lang kasi dinagdagan yung number ng directors or trustees. Ano ang kailangan to fill that additional director or trustee? Election at a regular or special meeting of stockholders or members duly called for that purpose, or in the same meeting authorizing the increase of directors or trustees if so stated in the notice of the meeting. Compensation of directors or trustees. Do directors or trustees have compensation? No. They shall not receive compensation in their capacity as director or trustees, except for reasonable per diems or honorarium yung tawag nila. Okay? Unless, number 1, compensation is fixed in the bylaws. If it is provided in the bylaws, then merong compensation. Pero generally, wala. If the board of directors granted compensation, okay, then pwede. So, yun yung 2 instances. Fixed in the bylaws and granted by BODs or BOTs. And approved. Okay, tandaan, and approved in a regular or special meeting. Okay. In no case that the total yearly compensation of directors exceed 10% of the net income before income tax of the corporation during the preceding year. Directors or trustees shall not participate in the determination of their own per diems or compensation precisely because of bias. If you will allow the directors or trustees to be the ones to determine their own per diems or compensation, malamang yan, hindi na reasonable yan, mataas yan. Okay. Corporations vested with public interest shall submit to their shareholders and the Commission an annual report of the total compensation of each of their directors or trustees. Liability of directors, trustees, or officers. Directors or trustees who willfully and knowingly vote for or assent to patently unlawful acts of the corporation or who are guilty of gross negligence or bad faith. Take note, they knowingly and willfully vote for patently unlawful acts, guilty of gross negligence or bad faith, or acquire any personal or pecuniary interest in conflict with their duty as directors or trustees, shall be liable jointly and severally for all damages resulting therefrom. Okay? Tandaan keywords, willful and knowingly vote for patent unlawful acts, guilty of gross negligence, guilty of bad faith, or those who acquire any personal or pecuniary interest in conflict with the corporation. Okay? A director, trustee, or officer shall not attempt to acquire. So, it includes kahit, tignan nyo, shall not attempt to acquire, kahit hindi ka nag-acquire. Okay? Shall not attempt to acquire. Basta nag-attempt ka. Or acquire. Shall not attempt to acquire or acquire any interest adverse to the corporation in respect of any matter which has been reposed in them in confidence and upon which equity imposes a disability upon themselves to deal in their own behalf. Otherwise, the said director, trustee, or officer shall be liable as a trustee for the corporation and must account for the profits which otherwise would have accrued to the corporation. This shall remind you yung discussion natin sa prelims with regards to partnership, okay, that any profits that is taken by the partner for himself, that should be for the partnership. He should account that for the partnership. Ganun din dito. Okay? Di ba partners as a trustee? Ngayon naman, that director, trustee, or officer shall be a trustee for the corporation. Meaning, he must account for the profits he has acquired by virtue of that interest. Okay? At ano yung rule natin or principle natin dito? Doctrine of corporate opportunity. Okay, it holds personally liable corporate directors, trustees, or officers found guilty of gross negligence or bad faith in directing the affairs of the corporation, which results in damage or injury to the corporation, its stockholders, or members, or other persons. Diba? This includes yung typical na example natin when, let's say for example, the corporation is looking for a real estate, strategic real estate, and you as a corporate director, nakahanap ka, but masyadong maganda yung real estate na yun, so nag-decide ka na sa'yo na lang yung real estate na yun, hindi mo na i-report sa corporation or sa board, you can be found liable for that. Okay, because of doctrine of corporate opportunity, you are withholding information that you should report to the corporation. Okay, and you will be liable for that. Sabi natin kanina, bad faith and gross negligence. Bad faith implies breach of faith and willful failure to respond to plain and well understood obligation. Okay? Diba? If there's an obligation to do, you do it in good faith. Okay? If you did not do it in good faith, of course, you have done it in bad faith. Gross negligence is the want of even slight care, acting or omitting to act in a situation where there is duty to act, not inadvertently but willfully and intentionally with a conscious indifference to consequences insofar as other persons may be affected. Not simple negligence but gross negligence. Okay? Sabi ko na kanina, no? Error in business judgment does not amount to bad faith or gross negligence. Of course, yung board of directors nyo or board of trustees nyo, there will be times wherein their decisions are not really good in terms of business. But as long as it is not done in bad faith, or it does not oppress anyone, it is not unconscionable, okay, then that business judgment is valid because of business judgment rule. Okay? There are times wherein the corporation deals with directors, trustees, or officers in their private capacity. Question, is the contract or is the deals between the corporation and the director, trustee, or officer valid contract? The answer is yes, it is valid. Okay? Ang sabi dito, it is voidable at the option of such corporation. Ano yung voidable? A voidable contract, balik kayo sa oblicon, a voidable contract is valid until annulled. So kung hindi yan inannul ng corporation, that will stand to be valid, although it can be annulled. Okay? Unless all the following conditions are present. Okay? Number 1, the presence of such director or trustee, yung kadil nila, yung kadil ni corporation na director or trustee, okay, in which the meeting was approved, was not necessary to constitute a quorum for such meetings. Let's say for example, 15 board of directors, ang kailangan mo to have a quorum is 8. Okay? And 8 lang sila. Nandun yung director or trustee na involved dun sa transaction. Okay? Then therefore, hindi mo na-meet yung condition. Why? Because dapat daw, yung presence ng director na yun is hindi kailangan to constitute a quorum. Ibig sabihin, kahit wala siya, dapat meron pa ring quorum. Okay? The vote of such director or trustee was not necessary for the approval. Parang dun din, kahit wala yung director or trustee concerned, okay, dapat kahit wala yung boto niya, valid yung act ng corporation. Okay, hindi kailangan yung boto niya. Okay lang na nandun siya, pero hindi siya talaga kailangan mag-constitute ng quorum, hindi siya kailangan na mag-vote. Okay? Kasi kung kailangan yung vote niya, maging questionable. Okay? The contract is fair and reasonable. Of course, it should be fair and reasonable. Okay? If the corporation is vested with public interest, it must be approved by the 2/3 of the membership of the board. Ito mahirap kapag vested with public interest. Why? Because the vote required is not majority but 2/3 of the board, of the entire board, not the quorum or yung present dun sa meeting but the entire board. In case naman ng officer that the contract has been previously authorized by the board of directors. Okay? So yun ang tatandaan nyo. Kapag yung dun sa A, B, and C, merong isang wala, such contract may be ratified by the vote of stockholders representing at least 2/3 of the outstanding capital stock. Okay? As long as there is full disclosure of the interest of that director or trustee. Okay? So, pwedeng magkipag-deal si corporation sa sarili niyang director, trustee, or officer. Voidable yan at the option of such corporation. Ibig sabihin, valid pero can be annulled or ratified. Okay? Unless mapakita na hindi kailangan yung director sa quorum, hindi kailangan yung director sa voting, at fair and reasonable. Kung wala yung isa dito, kailangan merong 2/3 ratification from the holders of outstanding capital stock. Yun yung ratification. Contracts between corporations with interlocking directors. Ano yung interlocking directors? Directors in a corporation is also a director in another corporation. So, pwedeng si Director A is a director in Corporation B and Corporation C. Okay? Except in cases of fraud and provided the contract is fair and reasonable under the circumstances, a contract between two or more corporations having interlocking directors shall not be invalidated on that ground alone. In other words, guys, hindi ibig sabihin na there is a contract between two corporations involving interlocking directors. Hindi ibig sabihin invalid na yun. Okay? Provided that if the interest of the interlocking director in one corporation is substantial and the interest in another is merely nominal, this contract shall be subject to the provisions of the preceding section. Ano yung preceding section? Ito. Yung dealings. So, kailangan yung interlocking director, hindi siya kailangan sa quorum. Hindi siya kailangan sa votation. Or meaning, hindi necessary yung vote niya, yung presence niya. And fair and reasonable. Okay? So, kapag merong contract between two corporations with interlocking directors, okay, as long as walang fraud at fair and reasonable, valid yung contract. Pero kung yung director na yun, ang interest niya sa Corporation A, for example, is substantial, ibig sabihin, Ano yung substantial? Exceeding 20% of the outstanding capital stocks shall be considered substantial. Ibig sabihin, that director holds more than 20%. Okay? Tapos yung sa isa naman na corporation B, nominal lang or maliit lang, less than 20%. Okay? Ang i-apply mo na rule is yung sa rule kanina, ito. Dapat hindi kailangan yung presence niya, hindi kailangan yung vote niya, fair and reasonable. Although, pwede siyang mag-vote, pwedeng nandun siya, pero hindi necessary yung presence at yung vote niya. Okay? Yun yung with regards to interlocking directors. So, tandaan niyo po yan. Disloyalty of a director. Where a director, by virtue of such office, acquires a business opportunity which should belong to the corporation, thereby obtaining profits to the prejudice of such corporation. Tapos na? Yeah. Pagtingin. Pagtingin. Wala akong bagay. May bagay mo? Klase na naman ito. Yan, nila ko. Okay. Ako na talaga.
Wala na. Pagdagas mo suwatan. Wala tayong bagay ikaw.
Ay, nilabas ko na.
Nagbayad na.
Yan.
Thank you, Jay.
Sige, ma'am. Sir, Ernie.
Sige, sige, Pet. Uy! Or a director by virtue of itong disloyalty of a director is consistent with doctrine of corporate opportunity. Okay? Meaning that director shall be treated as a trustee and all profits obtained because of that business opportunity withheld from the corporation, the director must account for and return all the profits. Unless the act has been ratified by a vote of at least two-thirds of the stockholders owning the capital stock. Okay? So, kaya nga sabi ko kanina, parang sa partnership, if you do those things, kahit pa sa tingin nyo wala namang masama, because you are a director, okay, any knowledge you acquire or any opportunity that you become aware of, you should report to the board. Okay? If you didn't report of that and later nalaman ng board na you withheld that business opportunity from them, they can hold you accountable. Pwede kang ma-save through ratification of the stockholders. Kaya meron pa rin corporate politics dyan. Kasi kailangan lang ng two-thirds ng vote nila para maging valid, para hindi ka maging liable. Then last slide, execoms and special committees. Execom, Mancom, special committees, executive committees, management committees, and other special committees. Of course, if the bylaws so provide, kung nag-provide lang po si bylaws, the board may create an executive committee composed of at least 3 directors. Said committee may act by majority vote of all its members. So, majority of all its members, majority of 3 is 2. Diba? 1.5, 50% plus 1, 2. They can act on specific matters within the competence of the board as may be delegated to it in the bylaws or by the majority vote of the board. Okay? Yun lang yung powers nila. Those provided by the board of directors. Okay? Except with respect, ibig sabihin, itong execom, mancom, special committees, they cannot act on these things. Number 1, approval of any action for which shareholders' approval is also acquired. Once that an act, lahat ng makita nyo dito na sinasabi kailangan ng approval ng stockholders or majority or two-thirds ng stockholders, hindi pwedeng gawin ng execom at mancom. Okay? Filing of vacancies in the board because that one needs the approval of the stockholders. Amendment or repeal of bylaws or adoption of new bylaws which needs the vote of the stockholders. Amendment or repeal of any resolution of the board which by its express terms is not amendable or repealable, and distribution of cash dividends to shareholders. They cannot act on these instances. So tandaan nyo yan. The board of directors may also create special committees of temporary or permanent nature and determine the members' term, composition, compensation, powers, and responsibilities. Okay? So, meron pa ba? Yeah. That is the end of our topic. Okay, good night.